Morning, everybody. I wish I could see you. I so want to reach out, but I'm just going to have to pretend I can see you. Thank you ever so much for joining. I'm praying that I can be seen and heard. If I can't, put something in the chat bar and then I'll know. We've got a tremendous attendance today and I'm going to get going. Now, in the old days, if you felt like having some training, you'd phone up to book some, and it could take ages to arrive and it could get quite frustrating. But in these modern days, at a touch of a button, you can have it delivered to your door in 2 minutes flat. This training session is going to be at most an hour and a half long. It's delivered live, so I don't know exactly how long it's going to take, but we'll definitely be finished by 11:30. I'm planning on breaking after about 40 minutes for about 7 minutes. But before we break, we're going to have a little poll with just 2 questions in it. So before you wander off on your break, please just take the time to answer those 2 questions. We've already had quite a lot of questions which have been asked over last week, and I've tried to answer those questions in my PowerPoint, but there's quite a few detailed matters that have been raised, for example, about detailed considerations regarding DBS. Which I haven't tried to deal with. But if you want to ask questions about that sort of thing, or indeed anything, then please use the chat facility and please feel free to contribute your answers. And I'll make sure that we cut and paste all of those at the end so that we've got a record of them. This session is being recorded, as you can probably see. And the recording is going to be posted on our website at Cornerstone Barristers, and it's also going to be posted hopefully later today or tomorrow on Local Government Lawyer. So it'll be a free resource for everybody, and that means that you will not have to be taking frantic notes during this session. Right, I'm going to try and share my screen and get on with it. So I just want to start by standing back from this and considering what the approach is of these standards. The underlying philosophy of these standards is described in the very first sentence. It is that taxis and private hire vehicles are a high-risk environment. Now, my comment about that is that when it talks about risk, it's not talking about the risk of tripping over some loose carpeting in a bar. It's talking about risks which are life-changing or life-ending, including for children and vulnerable people, the most important people in our society. So when you wander into the town hall next, if and when you do that, you're able to tell people that this isn't some tedious pen-pushing exercise for members and officers. It is amongst the most important things which you will be doing in your building. It is crucial work. And these standards represent a radical change of tone from the guidance, the taxi and private hire vehicles licensing best practice guidance of 2010, where it was said, well, the aim of this regime is public protection. But, it was said, balancing it almost in the same breath, the public should have reasonable access to taxis. Unduly stringent requirements, it was said, will restrict supply. So authorities should carefully consider whether the burdens they are imposing are commensurate with the benefits they seek to achieve. So this was all about balance, not imposing too great a burden on the taxi industry, but making sure that they were at liberty to operate, but of course with the appropriate safeguards in place. This is now really reversed. The overriding purpose is public protection, and everything is subservient to that. Origins and status. Well, the statutory origin of all this is section 177 of the Policing and Crime Act of 2017, which said that the Secretary of State may issue guidance to public authorities as to how their licensing functions may be exercised so as to protect children and vulnerable individuals who are 18 or over from harm. So that's the guiding statutory purpose. And it goes on to say that any public authority which has licensing functions under the legislation must have regard to any guidance issued under this section. Now, in this PowerPoint, I try and refer to what has emerged as standards, whereas the 2010 guidance is guidance. And if I slip up on that, apologies, but I'm trying to stick to the terminology of standards. Now, when must the authority have regard? And the answer is not when you get round to it. The answer is now. In other words, if you are exercising a function, any function, tomorrow, today, in relation to taxis or PHVs, you must have regard to the guidance right now. That doesn't mean you need your new policy in tomorrow. Obviously, you're going to do some work to implement these standards, but when you're exercising functions, you must have regard. There's no transitional provision, there's no wait. There was an old case called Gergo and Enfield, which said that you can write into guidance when it's supposed to come into effect, but there's no transition here. You have regard now. And what if you do not have regard? And there you've got a group of non-socially distanced barristers waiting in the wings. You'll be acting unlawfully. Now, this may feel like a banal question, but it's not really. What does have regard actually mean when you find it in a statute? Well, it means, said the court in Katoon, the Court of Appeal no less, that you must take the guidance into account. You can't depart from it just because you don't agree with it, just because you don't feel like complying with it. And if you are going to depart from it, then you have to give clear reasons for departing from it. That's important. The court's not going to fill in the gaps for you. You've got to explain what you're doing and why. What do the standards themselves say about this have regard duty? Well, they say that have regard means more than having a cursory glance before reaching a preconceived conclusion. My reaction to that is that's almost too obvious to need stating. If you fail to adhere to the standards, that could harm your position in court. And my comment about that is, well, it will harm your position in court if you haven't explained rationally why you have decided to depart from the standards. So it all depends on whether the reasons for departure can be shown. And it says the authority should publish their consideration of the guidance and the policies or plans stemming from these. And my reaction to that is a good idea and it's good practice. You should show the world how it is that you have taken these standards into account. Now there's another case about have regard where some further considerations were dealt with. And the first point which was made in that case, it was a High Court case, is that you have to pay greater deference to guidance which has been through a consultation process and has parliamentary sanction, and so has the force of statutory guidance. So whereas previously you might have had non-statutory guidance, you still have to take it into account and you have to give it due weight. This is something else. This is guidance authorised by Parliament, mandated by Parliament, and all of you will be aware of the very lengthy process of consultation which has led up to the publication of these standards. It was said there should only be departure for proper, i.e. clear and legitimate reasons. And you, the authority, have to demonstrate that you've considered and engaged with the guidance, not ignored it or merely paid lip service to it. Very often you'll read decisions from hard-pressed licensing committees say, well, the committee's had regard of the guidance, the policy, and all sorts of other things. But in this case, I'd strongly recommend that you do more than that and explain how you've had regard to it, what conclusion it has led you to. The reasons, it was said in the High Court case, don't need to be documented, but it's preferable if they are. I would add an adverb to that. It is strongly preferable if they are. It is your protection against judicial review. You need a proper evidential basis for a decision to depart from the guidance. And it must be clear from the decision that proper consideration has been given to it. Sometimes it'll be clear just by looking at the officer's report to you, and the court will often read in the advice in the officer's report as meaning that you've had regard to that advice and therefore the standards. Now, can the standards self-aggrandize? I mean, what I've said is that you've got to have regard, you've got to pay due regard, you've got to engage with it, you've got your reasons for departing from it. But can the standards themselves impose an even greater burden on you? Well, these standards try. They say the department therefore expects these recommendations to be implemented unless there is a compelling local reason not to. Can the standards write in the word compelling and make that a requirement of law? I don't think that they can. This compelling reasons test has not been endorsed by the courts. The guidance cannot levitate itself using its own bootstraps. If I'm made secretary of my local neighbourhood watch, I can't start passing bylaws in the council's area. The standards do what they do. They can't demand that you need a compelling reason to depart. But the clarity of the expression of the standards, the rather important tone through which these standards are conveyed, would definitely be taken into account by a court in any future challenge to an authority which disregarded the standards. But also remember, the standards are not law. This harks to a number of questions which have been posed in the last few days. In Katoon, it was said, guidance is not a source of law. And here's one of several cases decided in the court over the last 15 years since the Licensing Act and the Gambling Act came in, the case of Four Winds Leisure. It's important to remember that while regard must be had to the guidance, it should not be allowed to usurp the clear language in the statute. So the source of law is statute, the source of guidance is guidance. And the standards recognise this. They say they do not purport to give a definitive statement on the law. And I'd also say that what the standards mean is generally taken as a matter of law. You've got guidance of this sort. The courts won't construe it like a statute, but they will say that its meaning is a matter of law. Now, we've now got two lots of guidance, haven't we? Because we've got the best practice guidance for 2010, and now we've got these standards. How do they interrelate? And it is said the standards replace relevant sections of best practice guidance. Which sections are those then? We might have been told, but we haven't been. And we've also been told where there is a conflict, the standards have precedence. Well, where is there a conflict? That's a tough one as well. We might have been told. And in this regard, I can't help thinking that this is one of those documents which it was suddenly mandated had to be got out before the parliamentary recess, and there wasn't time for that fine-grained work to be done. What does this mean, this statement about how this guidance and the standards interrelate? Well, I think what it means is that whether the guidance is silent, then obviously the standards apply. Where relevant sections have been replaced, whatever those may be, then the standards apply. And it also obviously means, because it says so, that where there's conflict, the standards apply. And where there's no conflict, then they coexist. They each have force. And when there is doubt, then I think you're being told to work it out for yourself. It's not optimal, but in reality, when you put these two documents side by side, I've not really been able to detect much actual conflict. In most cases where they cover the same ground, it's pretty clear that the standards strengthen the guidance. And I think it's also really important to remember that the guidance is general. It's directed at the whole regulatory theme, while the standards are particular to the protection of children and vulnerable people. So clearly, they both have their place. Now, what about the relationship with wider licensing issues? And again, I think it's important to remember here that the standards have a limited purpose. They're not a cure-all. They don't cover every single thing about taxis and PHVs. For example, they don't deal, and they don't purport to deal, with cross-bordering, which is obviously one of the major themes and was the subject of many questions. They don't deal with the location of the PHV office. They don't deal with the question which comes up from time to time about the need for a server in the district on which bookings are accepted, and they don't deal directly with vehicle standards. However, and I think you get this from the standards themselves, if as a result of these standards you review your policies in the light of the standards, then it's recommended that you use the opportunity to revisit your policies in general. So this is a sort of galvanizing moment at which you can use the standards to inspire a more general review, because obviously local authority licensing departments have got nothing else to do at this particular moment in time. Implementation. Now there's implications for a whole series of different areas of local authority licensing work. And firstly, there are implications for policy. The standards recommend a cohesive policy document which brings together all taxi and PHV licensing procedures, including the fit and proper test, which we're going to look at, license conditions, which we're going to look at, and vehicle standards, which we're not. The standards recommend a really wide cohort of stakeholders on policy who should be consulted. I think this is really important, and I don't know whom you normally consult on your taxi licensing policy, but I suspect that this may be a broader cohort than have hitherto been consulted. So this includes disabled groups, chambers of commerce, obviously transport providers, campaigners, women's groups, local traders. Why is that? Well, because the local trade is the beneficiary of the taxi and PHV trade. Local multi-agency safeguarding groups, nighttime economy groups where appropriate. The nighttime economy is largely kept running on the ability to use taxis and PHVs to take people home, in some cities and towns at least. And also neighbouring areas where they are impacted. And in any case, there should be liaison groups between neighbouring areas. So this is a big task, and it's really important that you hear the priorities and concerns of this wide range of stakeholders. How often should you be doing this? Well, the standards say you should review your policy every 5 years. They also say that you should consider interim reviews if there are significant issues arising in their area. It almost goes without saying that if, heaven forfend, you turned into a Rotherham, that it's time there and then to have an interim review of your policy. And it also says that you should review your performance, and I suspect this means the performance of the licensing authority and not just the performance of the policy annually. Well, my view about that is that in most cases, policy should now be reviewed in the light of the standards. Maybe that doesn't produce very much of a change, but in order to show a serious engagement with these standards, it feels to me like this is a good moment to review your policy, however light touch that review happens to be. In many, and perhaps most cases, that might involve at least limited upgrading, maybe to some parts of the policy. And then I would say you should follow the standards regarding frequency of review, interim review, and the annual performance review. What about implications for licenses? Well, any changes in licensing requirements should be followed by a review of the licenses already issued, say the standards. So you can't sit on your 3-year or 5-year license and say, well, I'm completely immune from this because I've got it and what I have, I hold. That's not what the standards are saying. My view is that you should only review licenses if there are policy changes which are relevant to those licenses. And I also think that you should provide the licensee ample opportunity to raise their standards if your policy requires raised standards. For example, adaptation of vehicles, training courses, or improvement of language proficiency. Those would be examples. Well, this is an interesting little corner. What if you implement a tighter convictions policy than you previously had? What if, as a result of that, somebody is holding a license which they wouldn't be granted today based on their past misconduct? Well, the standards say you must decide each case on its merits, which is good advice for a licensing authority. And it also says where there are exceptional, clear and compelling reasons to deviate from a policy, you should consider doing so. Now, that could really be taken either way, couldn't it? It might mean an exceptional, clear and compelling reason to revoke someone's license or to allow them to continue their license, even though your policy has tightened. But what did raise my antennae was the idea of exceptional, clear and compelling. I've already said a word about compelling. I take the view that that sets the bar far too high either way. Once you've decided on your new policy, if there are licenses which then need to be brought in for review based on that policy, you should consider the risk to the public in the light of the new policy and come to a proportionate decision on the merits. And it's right that new information may come to light. The standards state that drivers should be subject to enhanced DBS checks and checks of the barred lists, both children and adult. Well, currently, it has been said that 10% of authorities don't do barred list checks. Well, if a barred list check reveals concerns, these should be taken into account. And I quote from the standards that in the interest of public safety, licensing authorities should not, as part of their policies, issue a license to any individual that appears on either barred list. So that's strong language, and its overriding purpose is clearly to protect the public, and the standards seem deadly serious in that regard. What about the duration of the license? Well, the standards say that licenses should be for the maximum duration permitted, except where the authority thinks a shorter license, in quotes, appropriate. Well, that's one of those areas where I'm not sure the standards add anything because they really only repeat the law. However, the standards strongly advocate interim checks and set out the means of achieving this. And I'm sure that most of you do this already, but the standards are very big on this idea that there's a web of knowledge which you can tap into to ensure that drivers are not only fit at the point of licensing, but remain fit during the duration of their license. And so linked to that, there are implications for scrutiny. There's a clear recommendation that you use the DBS update service, that you promote and you propagate a whistleblowing policy. I found that section in the standards not really that clear, but there needs to be whistleblowing within the local authority, so that if a licensing officer sees something, they shouldn't fear bringing it to the attention of the safeguarding officer. And those working for taxi and PHV companies, if they notice something, whatever their bosses say, they need to have the confidence that they will be protected if they bring it to the attention of the licensing authority, as they ought to, as a good citizen and as a regulated entity or an employee of a regulated entity. The standards talk about use of the common law police disclosure process through information sharing protocols. And they talk about the licensee bringing the attention of the licensing authority to anything the authority should know about them. They've been arrested, they've been questioned, they've been investigated, they have been convicted, they have been cautioned. With a failure to do that, calling into question their own honesty and suitability to hold a license. That's how important notification is. You shouldn't find out about driver misconduct by chance. And so this web of knowledge, if you look at this, this is the way to ensure that the people who are driving taxis and PHVs, the people who are dispatching them, the people who are taking bookings, the people who have knowledge about where vulnerable people live, about who's on holiday, which houses are vacant, all those people should be completely fit to exercise that office. And so referrals through the DBS, obviously, knowledge sharing with the police, sharing license information with other authorities, and the use of NR3 for that purpose. Multi-agency safeguarding hubs. So all the different authorities within and around a building, those with responsibility for safeguarding, working together to ensure the public is protected. Passengers are almost advertised as an important part of the safety mechanism. It's not about blaming the victim, it's about empowering passengers to protect themselves and to protect other passengers, enabling them to do that, giving them the information to do that, because in many, many cases, they are the eyes and ears in the cab. A robust system for recording complaints and analysing data and trends within the authority. In many cases, as you'll know, the data has been there just hasn't been the wherewithal for authorities to look at the data and see that there's a problem emerging. Drivers are a crucial part of this. They should have safeguarding awareness training. So if a child during school hours is taking a 15-mile journey, well, the driver should have training to understand that that's a clear safeguarding risk. What's the child doing? Where are they going? Why aren't they at school? And bring that to the attention of an authority. And an innocent phone call could uncover a serious criminal ring. And I would just add to that conditions that operators report complaints and complaints data. There is great variation about that regionally. I would say that the bar for reporting complaints should be a very low one. Sometimes there's a thought amongst operators that perhaps passengers are entitled to confidentiality and it's up to the passenger. Well, I can see that to a degree, but I can also see that it's not the case that a little knowledge is a dangerous thing. A little knowledge is very dangerous if it's not conveyed. And then there's implications for training. And commendably, the standards say that training on licensing is not enough. It's not enough to know what section this or that says. Authorities need to be trained in natural justice, which I think means hearing all parties before reaching a decision, the risk of child sexual abuse and exploitation, disability and equality awareness. So really imbuing counsellors with a sense of mission and purpose. Why are they there? And what are they doing there? They are such an important part of this web of knowledge and control. And then it says that we need to train them in making difficult and potentially controversial decisions. I'm not quite sure whether that's very helpful guidance. And it said that training should include case study material. You've just got to read the Casey report or the J report to understand why this is important. What is the point of this exercise? And I think that should be conveyed in training. And training should be formally recorded. Why is that? Because it frequently happens that you get into the High Court and the High Court gives a greater margin of appreciation or greater discretion, greater leeway to authorities when you're able to say, well, these members were formally trained. They knew what they were talking about. And here's a recording of the training. Here is where they signed for training. Here's where they did refresher training. And then the court is likely to say something like, well, we'd better butt out because we're not administrators. This is best left to the local administrators. And then implications for decision making. The standards have quite a bit to say on levels of decision making. They recommend that members should be deciding contentious matters and that officers should be deciding less contentious matters via a transparent scheme of delegation. Why is that? Well, the standards explain. This way you get a separation between the investigator and the decision maker. You get an oversight of the licensing service. In other words, the members get to peek in to how the licensing service is conducting its business, and it helps an all-round appreciation and all-round knowledge of how this regulatory scheme is working. And also it enables licensing officers to continue relationships without being seen as the decision maker. You know, my friend, I did not suspend your license. It went up to these impartial arbiters who are the elected members. So that is what the standards have to say on the topic. The standards also say that whether the structure proposed is introduced, this is the bifurcated structure I've just referred to, or an alternative model is more appropriate in local circumstances, the objective should remain the same: to separate the investigation of licensing concerns and the management of the licensing process. Now, my comment about that is that that does seem to countenance the possibility of an alternative model, for example, that officers generally take the weight in dealing with licensing determinations, but you need to provide reasons why you're doing that. But I do question the phraseology a bit. I think it's possible that the intended separation that the draftsperson was aiming at was a separation between determination of the case and the investigation of the case. If I've misread or misinterpreted, then I apologize. And then the standards have something to say about when there needs to be urgent determination. The driver's just been arrested for a serious sexual offence, for example. Well, regardless of which approach is adopted, it said that authorities should make arrangements for dealing with serious matters that may require the immediate revocation of a license. And it's recommended by the standards that this is delegated to a senior officer with responsibility for the licensing service. And obviously, if there's going to be some kind of peremptory suspension or revocation, then that has to be dealt with at a very senior level. Now, my comment about all this is that some authorities are enormous in terms of the number of licensees they have and the amount of work there is. And they've just got too much work to feed to members. And I don't necessarily see a legal harm in having contentious matters, even including revocations, decided by officers. But I do think that if you're going to have officers dealing with things like revocation and suspension, they should be a senior independent officer dealing with it, again, independent of the investigation and operating due process, because that will avoid allegations of malice on appeal. I mean, I guess it occurs to me that it would be a little bit like having a disciplinary process in an office. You might have HR investigating something or a department investigating something, but when the chips are really down and there's the possibility of significant disciplinary sanction, you'd want to wheel out somebody very senior within the organisation who hasn't previously been involved in the case. It's the same sort of concept. I would also make a suggestion, not a prescription, but you might decide to provide that only committees may revoke or suspend, or perhaps only committees may revoke or suspend, except in the most urgent cases, so that if an officer considers that revocation or suspension may be appropriate and it's contested, then it's referred up to a panel of members. So you've got every possibility of dealing with this firstly by members or by officers or by some hybrid in between. Whatever you do, as long as you explain it, you will be beyond legal challenge. Whatever you do, you've got to review your delegations and make sure that proper provision is made for them in the light of the said guidance, standards, in your standing orders. And then the standards take it upon themselves to give you some basic rules regarding decision making. So they refer to the members' code of conduct. They say you've got to have regard to human rights. They say you've got to observe natural justice. They say that your decisions must be reasonable and proportionate, because I guess no authority would like to set out to make decisions which are unreasonable and disproportionate. So it's very helpful the standard said that. The hearing has to be fairly conducted. All relevant factors have to be taken into account. You've got to avoid bias. You've also got to avoid predetermination, and you've got to take account of data protection legislation. Well, benevolently, let's just refer to that as a checklist to make sure that your member training is done well and properly. I have noticed that the little ladybird cover that I put up has a misplaced apostrophe after the word egg, which is deeply disappointing. So I think we'll take a little break there. It's 10:38, we're nicely on time, and we're going to break until 10:45. But before we do, I'm going to stop sharing the screen, and I think, with any luck, that Carolina is going to put up a poll. Oh, great. Here's the poll. Please fill out these 2 questions before you have your break. If you thought there was a 45% chance that a driver was a murderer, would you allow your maiden aunt to travel alone with him at night? You can only answer yes or no to that question. And on that basis, would you license him? Yes or no? I will leave you with that. Take a couple of minutes to answer that. Go make yourself a quick cup of tea, and I'll see you back here at 10:45. Well, welcome back, and hope that gave you long enough. And thank you for everyone who's answered the poll. I'm not sure how many of you have. Let's see. Carolina, I think, is going to post the answer. And, well, this is interesting. If you thought there was a 45% chance the driver was a murderer, would you allow your maiden aunt to travel alone with him at night? 6 people said they would. I think one of those might be Lorna Hudson, whose answer was, it depends if you like your aunt. Scary. But 98% of people said no, of course you wouldn't put your maiden aunt in a taxi if you thought there was a nearly 50-50 chance the driver was a mass murderer. But would you license the driver? 95% of people said no, they would not. Well, I think that's interesting. And I'm just going to put that up against what the fit and proper test says. Let's turn our attention to that. Thank you for your answers. I find this very interesting. The fit and proper test. Now, in various places, the statute says the authority shall not grant a license unless they're satisfied that the applicant is a fit and proper person. So the question is whether you're satisfied. The Act does not set out the standard of proof. Does it mean that you should be just about satisfied? Or does it mean you should be satisfied on balance? Or does it mean that you're fully satisfied? Well, I slightly let you off the hook in my question by posing the suggestion that there was a 45% chance that the driver was a mass murderer. What if there was a 5% chance? So you're 95% sure that the driver isn't, but you have a 5% lurking doubt that this driver is a mass murderer. What do you do then? Well, if you need to be sure beyond reasonable doubt that the driver is fit and proper, then you just don't license, because your overriding aim is to protect the public, including children and vulnerable people. But if the answer is satisfied on balance, then that might lead you to a different result altogether. You might feel compelled to license the driver because on balance of probability, the driver is fit. Now, there is binding authority that satisfied means satisfied on the balance of probabilities. And I find that troublesome, and I don't find it less troublesome when I read what the standards have to say about it, although I don't blame the standards, and I don't blame the very good people and very good licensing lawyers who've expressed a statutory test. The problem lies in the approach to the test adumbrated by the courts. Sometimes when you get a statutory test that's quite straightforward, there's a temptation to apply a proxy test, to say, well, what this test means is, and then a slightly different test is imagined. And sometimes the courts say, well, you shouldn't do that because that's glossing the words of the statute, or it's imposing a proxy test. Just focus on what the statute says. Now, these standards do not adopt a proxy test, but they suggest a way of approaching the statutory test. And this is what they say. They say that authorities have a duty to ensure the applicant is fit and proper. Can I just interpolate there? That's what you were doing when you said you wouldn't let your maiden aunt travel, and you wouldn't license somebody if you had a 45% doubt on the matter. You're saying, I'm not putting my maiden aunt in a taxi unless I'm sure that this driver is not a mass murderer. So the standards reflect what feels like common sense. The standards go on to say they might consider, would you allow a person for whom you care to travel alone in this driver's vehicle day or night? And that's a slight adaptation of something you find in the textbooks and find in the IOL's guidance on driver standards. And it then says, if on balance of probabilities, the answer is no, don't license. Well, just think about that. Put that against the first bullet point where the test is ensure, and the third bullet point where the test is balance of probabilities. Those aren't the same test. And it goes on to say, which we all know, you can consider conduct which did not result in conviction, either because it was never charged, or because it was charged but did not lead to conviction, because the test in criminal cases is satisfied so that you're sure. Now, my view about this, bullet point for bullet point, is that the first bullet point is just wrong because it doesn't comply with what the case law says. I think it's logically right, but it's legally wrong. And then the proxy test, if there was a 10% chance he was a dangerous criminal, the answer must be no, you wouldn't allow your maiden aunt to travel. You've just proved it, haven't you, with 98% of you saying no, you wouldn't. But how do you reconcile that with the balance of probabilities? And then, as against the statement, if on the balance of probabilities the answer is no, don't license, my comment is, well, what has to be decided on balance? Is it, would I entrust my maiden aunt to his care? Or is it, is he a dangerous criminal? Those are not the same thing. So I take the view that there's significant uncertainty about that, which we've all lived with. But once you decide for yourself that you don't want to take a chance with your kids and with vulnerable people, to my mind, this test needs a little bit of recalibration. And it comes up again in the context of rehabilitation. The standards say the authority should take a particularly cautious view of offences against children and vulnerable people, sexual offences and organised crime. Well, of course you should. There's a 1% chance that you've got a driver who's drug running using kids. Why are you licensing that person? But if the test is balance of probabilities, you might feel compelled to. And so my question is, do the standards mean that for such offences, a lower standard is required before refusing a licence? Or does it mean that where such offences are established on balance, the authority should be particularly careful before they do licence? This is not clear, but having regard to McCool, logically, it can only mean the latter. Well, my view about all of this is that it is time to revisit McCool. And this may be the time for somebody to take this off to court and get that done. Convictions policies. According to the standards, there should be 3 categories. There are offences so serious that the applicant should not be licensed except in truly exceptional circumstances. And then there are offences where a number of years should elapse before somebody can expect to have a license again. And then there are offences which would not by themselves normally justify refusal, for example, single minor motoring offences, but might if a pattern is shown. Now, in relation to the second category, that is periods which have to elapse, I put this guidance up against the IOL guidance, and in every single case, the same periods have been adopted. So if it results in death, never; violence, 10 years since completion of sentence, and so on and so forth. But what of multiple convictions? To my mind, a little bit surprisingly, the IOL guidance has not been adopted. The IOL guidance is that where an applicant has more than one conviction showing a pattern or tendency, irrespective of the time since the convictions, serious consideration will need to be given as to whether they're a safe and suitable person. Well, the standards just haven't adopted that, but my view is that makes a whole bunch of sense and should be adopted, because somebody may have had 4 or 5 speeding convictions, that puts their passenger at risk, and that may show a propensity to drive quickly. And it may be said, well, drivers drive 50,000 miles a year. Of course, they're going to speed from time to time. The answer to that is they are professional drivers, there to protect the public, and it's their duty to drive within the law. If a pilot repeatedly flew in a dangerous manner, it would not be a defence that he has to fly or she has to fly 1,000 hours a year. It just wouldn't add up. They would lose their ability to fly altogether. So my view is this is an area where the standards are silent. It would be perfectly in order, and I believe right, to adopt the IOL standards. And then there's other standards in the IOL guidance based on other motoring convictions. I'm not going to repeat all of those, but those again are not replicated in the standards. The standards simply set out a very general piece of guidance. Again, in my view, it's open to a council to go with the IOL on this, but it should acknowledge it's done so with reasons. Now, how rigid are these standards? Well, the standards say never means never. So where the standards say will not be licensed, they're guilty of murder, they're not going to be licensed. They say never means never in all but truly exceptional circumstances. Now, in relation to lapsed periods, there's some inconsistency here. The standards say lapsed periods should be a starting point which prioritizes passenger safety while allowing for offenders to evidence rehabilitation. So you take them as a starting point, and that indicates from the starting point you could move up or down. But the standards also say that authorities should consider each case on their merits, fair enough, and that applicants are entitled to fair and impartial consideration, fair enough, but the periods given should be a minimum. Well, they can't be both a starting point and a minimum. And so they are irreconcilable. And this is another area where I think something has perhaps been a little bit rushed or hasn't been looked over by departmental lawyers with the care and attention which in other cases they might have received. I think those words are irreconcilable, and authorities should take the pick in their policy. I have to say that my inclination is you try and strike it right in your standards, and then you can move up and down from there depending on the exigencies of the individual case. To say that something is a minimum is not really very meaningful and doesn't help you work out when you might do less or more. Treat them as a starting point, but look at the merits of the individual case. Drivers. Driver conditions. Well, the standards say that drivers should have safeguarding awareness training, both on CSAE and on county lines. I think that's excellent. It says they should have language proficiency. And it goes quite a long way here, because in relation to oral, this isn't just understanding the customer that says, can you please take me to the nightclub, or I've got a chest pain, please can you take me to the hospital. It's to identify safeguarding issues, it's to pick up the nuances. But also they should have written proficiency so that they understand policy and guidance. And there's been a bit of litigation about this in one of the Uber cases in 2017, which established the proportionality of the language requirement. Now, what if you have a driver who is already licensed but struggles to communicate? You uprate your guidance and say the driver needs to have oral and written communication skills. What do you do about that? And my view about this is that you have to take a view. Once you've implemented that policy, you've got to take a view. If you decide that in your area communication is key, then I suppose it's possible that you give the driver a period. It might be months, it might even be years. I don't know, it's up to you, to bring their communication up to scratch. Now, I think there are other conditions which might be considered. And these are just my suggestions. If you're going to upgrade your policy, here are the sorts of things you might bring into account. First of all, security checks. Only 90% of authorities require enhanced DBS and barred list checks, whereas 10% require enhanced DBS only. I say only 90%, I mean that. The 10% of authorities should wonder why they're not doing barred list checks. They should do disability awareness training, it said. Only 41%, sorry, that's my idea, that only 41% of authorities require this. I wonder whether that number shouldn't be 100%. Medical examinations, local knowledge. I'm not sure that just being able to find your way around using Waze or Google Maps or something else is enough. Sometimes you need to know some particular things about your area, and you may decide there should be local knowledge independently of the ability to use SatNav. Based in district, this came up as a question in the case of Delta and Knowlsley MBC in 2018, and there was what lawyers call an obiter dictum, which is not necessary for the decision, but it came up incidentally, in which the judge thought that conditions could be imposed on a license which required a driver not to spend their whole life travelling out of district. And I take the view that there's a potential for a condition which requires drivers to be based in the district which licenses them. Display of information and notification of arrest, charge or conviction for relevant offences. Those are all the sorts of things which I think might legitimately go into a licensing policy. CCTV is obviously a massive topic, and it felt to me reading this document, these standards, that what we have now is a sort of cautious endorsement of CCTV. I don't quite understand why the department has not really wanted to grasp the nettle on this. And I think that it's even more guarded than the 2010 guidance, even though CCTV has just become a very natural part of our daily lives. Most of us don't think about it at all, that we're on CCTV. Campaigners do, but I'm not sure that most other people do. The standards say that CCTV can deter crime, they can reduce fear of crime, they can assist the police, they can assist insurance companies, and it says that authorities should consult on having CCTV. And the standards say that the experience of authorities mandating it has been positive. So that's all to the good. But then they say, I find rather curiously, but crimes still occur with CCTV, as though that perhaps that's a reason not to have CCTV. But if that is what the standards are saying, that would also be an argument against having a police force. Well, we've got a Metropolitan Police, absolutely marvellous, but it has to be said that crimes still occur despite the presence of the Metropolitan Police. So we should have a real think about whether we need the Metropolitan Police. If that's what the standards are saying, it doesn't feel to me like much of an argument at all. Continuous recording. Well, the driver finishes their day's work and then they go off shopping. Have they got to be recorded the whole time? And the standards say it should be possible to switch off the CCTV when it's not being used for hire. What about our audio? Well, the standards say that audio should be overt so that everyone knows it's on. It should be targeted, so it shouldn't be continuous. People are entitled to have private conversations in the back of a cab. It should be operable by the driver or the passenger. So a passenger threatens a driver. The driver should be able to say, look, I'm turning the recording on now to protect the driver. It should be capable of being turned on by the passenger. They're propositioned or something. The argument starts. The passenger should be able to say, for my protection, I'm turning this on. And the whole question of audio should recognise passenger privacy. Now, what's my view about this, for what it's worth? It seems to me that CCTV is an important deterrent and detection device. It protects the public and drivers. It reduces the fear of crime and assists insurance companies investigating incidents. It is a cost, but it's a justifiable cost. And it seems to me that operators, particularly the big operators, should be trying to find ways of swallowing that cost for their drivers. But presently, only 4% of authorities require CCTV. The requirement, of course, needs to be justified in data protection terms. I have to say If I was taking a cab ride and someone said to me, the cost of this ride has been increased by a penny this year to pay for CCTV in this cab to protect the public, I wouldn't have much problem with that penny. Privacy, of course, customers have to be informed of CCTV. They should be told about it on the website, the standards say. They should be told about it by automated messages on their phone, and they should be told about it in the car. So subject to all of that, I think there's a strong argument for this being a new generation protection within cars. I mean, there's enough allegations of sexual assault and rape and what have you in taxis and PHVs. If they have to be in off licenses, why on earth they don't have to be in cars? Traveling around in the middle of the night, a lone customer with an experienced driver, I find that quite difficult to understand. Operators. The standards say that the fit and proper test should be applied to all directors and partners. It says operators should notify changes in such personnel. Authorities should be satisfied that customer-facing staff don't pose a risk. Authorities should require a register of staff who are taking bookings and dispatching vehicles. And operators should provide their policy on the employment of ex-offenders. So this is not just the corporate entity, but it's those who are responsible for delivering the service. They need to be monitored. I've got quite a lot of views on this topic, probably more than I can go into with any degree of thoroughness in this webinar, but I do think that the standards are extremely skeletal. And I think that when they do review their policies, authorities should consider a whole bunch of further conditions. I think that as we're getting into the era of larger operators with big data systems, that they become a crucial part of the web of control. And if you look at how the Gambling Commission regulates big online operators, they are the harbingers of, they're the harbourers of information, or the holders of information, which help the regulatory authority to protect the public. And so I think there's room to condition advanced corporate compliance systems, particularly for the bigger operators who've got the computer networks which enable that to happen. Board oversight of the compliance systems to make sure that the board is actually exercising oversight in the same way that football clubs need a safety officer and need to have the board looking at the issue of safety on a regular basis. Documented risk assessment in relation to their drivers. 22% of drivers working 7 days a week. What happens when they're exhausted? Who's looking at that? Who's supervising that? Documented risk assessments regarding safeguarding, ride sharing, hotspots, and the appointment of a compliance and/or police liaison officer, an independent audit of compliance and the supply to a regulator, the way complaints are handled, the way they're recorded, the way they're reported. Are they reported to the licensing authority or the police or both? And also where the complaint occurred and/or the district that the license is held. In other words, should you be reporting if a Manchester license is held but the complaint happens in Sheffield, should the complaint go to Manchester and Sheffield or Manchester or Sheffield? The regulator should have access to complaints records and some kind of law enforcement portal. Perhaps the regulator should also have access to the whole pattern, the whole statistic, the whole bank of statistics in relation to complaints data, so that they can check how complaints are being handled and what the outcomes have been. All of that is important stuff where I actually think that without great cost to the licensing authority, the operator becomes a really crucial part of the solution. In other words, they perform part of the licensing authority's role for them, because the licensing authority does not sit at the hub of the operator, but can rely on the operator to do the job. There should be some system for reporting of key events, like systems changes, systems faults. For example, It might emerge that people have been able to drive without insurance or a license. Serious offences, suspensions, data breaches or losses, or investigations by other regulators. And clearly we've seen in recent years how most of those things have occurred within the taxi industry, and it's really important that those are treated as key events and reported very promptly. Cooperation with investigations remotely or on site, and cooperation with enforcement officers in other areas. And I take that from the Al-Haq Task and Finish Group, recommendation number 9. I think that there could be conditions in relation to wheelchair accessibility. Only 5% of authorities require all or part of a PHV fleet to be accessible. Well, maybe they should all require at least some parts of the fleet to be accessible, or some part of the fleet, once X vehicles are reached by the operator, to be accessible. Apps are all very well, but sometimes customers, particularly if they're in a state of panic, or they don't have their phone or are borrowing someone else's phone, they just need an emergency phone line to call. There's discussion in the Delta case about whether officers can be made to be in the district. There's discussion in the case of Blue Line about whether operators should have local phone numbers or whether they're permitted just to have regional or national phone numbers. The supply of trip, geographic and hotspot data to the regulator, which I understand happens in New York. Maybe they should have clean air plans. Maybe there should be some restriction of drivers' hours at operator level. To my mind, there should be hours on the app, not just hours actually driving. If the driver's on the app, they're out of their house, they're not in their bed, they're sitting in the driving seat. So how many hours are they doing that for? There should be some risk assessment of drivers. It's great if they're only on the app for 8 hours a day, but what if they're working in a pub for another 8 hours a day? Drivers should be risk assessed to ensure that when they turn up for work, they're fresh as a daisy and ready and alert. There should be perhaps supply of data on driver hourly and weekly earnings. Why? Because that impacts on public safety. If the driver's not earning enough, they may be inclined to drive for much longer hours than are safe. And so the operator needs to understand that. There should be an ability for passengers to register concerns about those with whom they've ride shared. That's also part of the web of control. And eventually there should be driver verification by either biometric or face recognition log-on technology to ensure the person who has the license is the person who's doing the driving. So I think big data has really rocketed the taxi and PHV industry into a new era, largely to the benefit of the customer. But the corollary of that is that the regulator should be grasping the opportunity to turn those technological systems to the advantage of the public to ensure that the system is entirely safe. And then enforcement. The standards say that there should be joint authorization of enforcement officers inside and outside the district. See the LGA handbook for a model, which is really good and could be used. Ensure that drivers understand the policies they're supposed to be adhering to. Consider use of a points-based system to aid consistency. Ensure there's a clear, simple and well-publicized system for public complaints. And also, say the standards, consider the use of suspension pending additional training where this is appropriate. So a driver says, look, I'm really sorry this went wrong. I didn't quite understand what the requirements were, but I'm booked on a training course in 2 weeks' time. Well, consider suspending the driver for those 2 weeks if their lack of training has led the public into danger. Now, here are my comments about enforcement. This system depends on effective regulation. The case of Wakefield, actually read carefully, allows you to raise fees to cover the entire compliance function. Use it. If you impose a higher fee on an operator to fund your necessary enforcement work, don't worry. The operator may have to cascade that cost down in the millions and tens of millions of customer journeys to ensure that the public is protected, and they may have to swallow a little in their national, or indeed in some cases their global profits. Don't be the latest Rotherham. How much compliance monitoring and enforcement is required is not a political question. It's a professional judgment. It's what you've been put in place for. And if you say, this is how much enforcement we need to have, don't complain that you don't have the resources to send officers out to the neighbouring district. You do have resources. The question is who pays for it. And it shouldn't be the local authority. You should be able to raise those funds from the people whose activities are causing you to need to send officers out to the neighbouring district. That is the appropriate cost of regulation. I think you should regulate smart. I think you should require operators to provide you the data you need for efficient monitoring using conditions, for example, trip and hotspot data. Your officers should be equipped with body-worn cameras, so there's never a question about what was said. I think you should use social messaging aimed at drivers, reinforcing key messages. I think you should think and think and think about joint working with other authorities, DVSA, police, trading standards, environmental health, whatever is needed. I think that joint operations are a powerful tool. And not just joint operations with other authorities, but also with police, because of the police wider powers in relation to stop and search. And there should be intel sharing protocols. You should use your prosecution and suspension and revocation powers for deliberate or serious or repeated non-compliance. That has a deterrent impact. It explains to the world that you operate a safe system and you will not have unsafe operators or unsafe drivers on your roster. Penalty point system is effective for minor breaches. NR3 is a great tool, obviously. Make sure that complaints are monitored. That is a cost to ensure that happens, but it's a cost which you can share with operators and drivers. Don't be another Rotherham. I think that the public need increased clarity on how to complain, to whom to complain. I suspect the complaints go in several different directions currently, going back to the Manchester and Sheffield example. If the passenger has a Manchester driver, but something happens in Sheffield, do they complain to the licensing authority in Manchester and Sheffield? Or do they complain to the operator? Or do they complain to the police? I don't know. You had better work out what your policy is and ensure that there's a conduit which ensures the complaints data to be properly collected. And all of that produces a culture of compliance, and it means that the public, including vulnerable people, benefit. Out of district enforcement is obviously a massive topic. It's the one which comes up more than any other in my experience. The standards talk about joint enforcement operations between home and away authorities, a protocol for reports of non-compliance by the away authority to the home authority. I believe there should be such a protocol, using where necessary body-worn footage, even about small things like illegal parking or vehicle defects. This is all part of understanding whether the cars you licensed are complying wherever they happen to be driving. And obviously this idea of authorising officers from other authorities to use enforcement powers on your behalf. And passengers should be enabled and empowered. And you enable people by educating them. They should be told how to see if a vehicle is licensed. How many cases have arisen because somebody has stepped into an unlicensed vehicle? They should understand the difference between taxis and PHVs. They should understand the dangers of using a PHV that has not been pre-booked. Completely off the system, off the grid, nobody looking in, nobody understanding where you're going, and so on and so forth. That is dangerous activity. You may as well get into anybody's car as get into a PHV that has not been pre-booked. They should arrange to be picked up from a safe place so their friends can see them getting into a car. They should note the license number, particularly if anything happens. They should sit in the back, never as a passenger. You can avoid it, certainly not if you're traveling alone. Sit in the front. They should inform the third party, their mum or dad or husband or wife, of their journey. And they should, wherever they can, use taxi ranks for taxi journeys. This is all part of the way that passengers themselves can contribute to a safe system for everybody. So there's quite a big agenda there about thinking about how conditions can be brought onto the license, and much better systems of control are operated. Some authorities are right up on this. Other authorities are maybe a little bit further behind, but all authorities, I think, should be trying to bring themselves up to a new, higher standard. So I get to my conclusion. My belief is this, that these standards throw focus on children and vulnerable people. What has happened in recent years in some areas is just utterly stomach churning. So insofar as these standards throw that focus, cast this new light on the needs of children, vulnerable people in transportation systems, they are important. And also in that they raise the standards of licensing. As I say, this isn't some administrative bureaucratic exercise. This is an extremely important job of keeping the public safe. And it has obviously been a very, very long time coming. My minor observation is that although there's been a long gestation period, the standards are not always clear. When you read them, it's obvious that they lack detail in several areas, and in some others they just tell authorities what authorities already know. However, these are minimum standards. It's up to authorities to raise their standards to protect their communities, both through their policy work, through member officer training, and then of course through implementation during the license grant and renewal process, and in any reviews of licenses which happen because of knowledge which comes in to licensing authorities. And I do have to say, from my experience, if authorities do raise their standards and then take action based on those standards, explain what they're doing, explain what these national standards are doing, explain how they've been translated into local action through policy, member training, implementation through licenses. If all of that is explained to Magistrates' Court or indeed to the High Court, the court will support you in that endeavour, because it is a very important one. That's it. Thank you for listening. Keep the questions coming, and very best of luck as you take these standards forward. Thank you so much for joining us.